The defence of provocation holds a significant position in criminal law of Western Australia, particularly under the Criminal Code Act Compilation Act 1913. This defence is crucial in cases involving assault, as it allows an accused person to claim that they were not criminally responsible for their actions due to provocation. What constitutes provocation? Provocation, as defined in Section 245 of the Criminal Code Act Compilation Act, refers to any wrongful act or insult that is capable of depriving an individual of self-control, thereby inducing them to commit an assault. The definition is broad, encompassing both physical acts and verbal insults that have the potential to trigger a loss of self-control in the accused. The concept of incitement is central to understanding provocation, as it implies a deliberate effort to provoke a reaction from another individual. The case of Horlatsch vs. Thomas is instructive in understanding the application of provocation in Western Australian law. In this case, the court emphasised that incitement involves a mental element, such as urging or stimulating another person to take action. This interpretation underscores the idea that for provocation to be valid, there must be an element of deliberate stimulation or persuasion that leads to the accused's loss of self-control. However, the distinction between wrongful acts and insults has been a matter of legal debate. In Stingel v. The Queen, the High Court of Australia clarified that the term wrongful should apply only to acts and not to insults. The court recognised that requiring an insult to be wrongful could create undue complications in distinguishing between rightful and wrongful insults, which could potentially undermine the defence of provocation. Elements of provocation. The accused must demonstrate that they were in fact deprived of the power of self-control due to the provocation. This element is subjective, focusing on the actual state of mind of the accused at the time of the offence. 2. Sudden reaction. The act of assault must have occurred suddenly before the accused had time to regain their composure or for their passion to cool. This requirement ensures that the reaction was immediate and directly linked to the provocation. 3. Proportionality of force. The force used in response to the provocation must not be disproportionate to the provocation itself. Additionally, the force must not be intended to cause, and should not be likely to cause, death or grievous bodily harm. The defence of provocation thus requires a careful balancing of subjective and objective elements. The subjective test focuses on whether the specific conduct of the victim caused the accused to lose self-control. Meanwhile, the objective test examines whether the provocation was severe enough to cause an ordinary person to lose self-control and react in a similar manner. What does not constitute provocation? Not all actions or insults qualify as provocation under Western Australian law. For instance, lawful acts do not constitute provocation. This includes situations where an individual is arrested lawfully, as such an act cannot be considered provocation, even if it leads to an emotional response from the accused. However, there are nuances in cases involving unlawful acts. An unlawful arrest, for example, may not automatically amount to provocation, but it could be considered as evidence of provocation if the accused was aware of the illegality of the arrest. This distinction highlights the importance of context and the specific circumstances surrounding the alleged provocation. The test for provocation in Western Australia involves both subjective and objective components. The subjective test examines whether the conduct of the victim actually caused the accused to lose self-control. The court assesses the personal characteristics, experiences, and mental state of the accused to determine whether they were genuinely provoked. The objective test considers whether the provocation was severe enough to cause an ordinary person to lose self-control. The ordinary person standard is critical here, as it introduces an objective benchmark against which the accused's reaction is measured. The ordinary person test, derived from Stingel v. The Queen, involves a two-stage process. First, the court must assess the gravity of the provocation, taking into account the nature and seriousness of the wrongful act or insult. Second, the court evaluates whether an ordinary person, when faced with such provocation, could have lost self-control and reacted in a similar manner as the accused. The subjective element of the test, as further elaborated in Stingel, requires that the provocative conduct be viewed from the perspective of the accused. This means that the particular characteristics and experiences of the accused are relevant in assessing the impact of the provocation. However, the final question remains whether an ordinary person, placed in the same situation, could have reacted in the same way. A crucial aspect of the defense of provocation is the extent to which the accused lost self-control. The court's inquiry is not merely whether the accused experienced some degree of anger or frustration, but whether the loss of self-control was so significant that it explains or partially excuses the offending behavior. This loss of self-control must be substantial and directly linked to the provocation, rather than stemming from a pre-existing disposition to violence. The case of Moffa versus the Queen provides valuable insight into the application of this principle. In this case, the High Court highlighted the need to consider the entire context of the victim's conduct when assessing provocation. Even if individual acts or words may not suffice as provocation on their own, their cumulative effect could be sufficient to cause a reasonable person to lose self-control and engage in the kind of violence that led to the offence. This holistic approach to provocation recognizes that human reactions are often complex and multifaceted. The law acknowledges that a series of minor provocations, when combined, can have a profound impact on an individual's state of mind, potentially leading to a loss of self-control. In Western Australia, provocation serves as a partial defence to murder, reducing the charge to manslaughter if successfully invoked. This partial defense reflects the legal recognition that certain psychological reactions triggered by the victim's behavior can diminish the moral culpability of the accused. However, it is important to note that while words alone can amount to provocation, it is rare for verbal insults to suffice in the context of a murder charge. The two-part test for provocation in cases of homicide is the same as for other offences involving assault. The court must be satisfied that the conduct causing death resulted from the accused's loss of self-control, which was induced by the victim's actions or behavior. Furthermore, the victim's conduct must have been severe enough to cause an ordinary person to lose self-control to the extent of forming an intent to kill or cause serious harm. The ordinary person test plays a critical role in this context. It ensures that the defense of provocation is not applied too broadly, but is instead reserved for situations where the provocation was genuinely capable of triggering a loss of self-control in an average person. This test also serves as a safeguard against the misuse of the defense by individuals who may seek to justify premeditated or disproportionate acts of violence. The defence of provocation in Western Australia is a nuanced and complex legal concept that balances subjective and objective considerations. While it provides a potential defence in cases involving assault and to a limited extent homicide, it is also subject to significant limitations. The defence requires a clear demonstration that the accused was provoked to the point of losing self-control and that this loss of control was reasonable given the circumstances. The application of the defense of provocation underscores the importance of understanding the interplay between human emotions and the law. It acknowledges that while the law must hold individuals accountable for their actions, there are situations where the actions of the victim may partially excuse or mitigate the culpability of the accused. In practice, the successful invocation of the defense of provocation requires a thorough examination of the facts, careful legal argumentation, and a clear understanding of both the subjective experiences of the accused and the objective standards of reasonableness. As such, it remains a critical but carefully circumscribed area of criminal law in Western Australia.